Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. Last night, a slew of filings came in to the Justin Baldoni versus Blake Lively case. One of those filings was a letter from Blake Lively and Ryan Reynolds in regards to the request for extension of time that Justin Baldoni and Wayfarer's attorneys had submitted 2 days ago, explaining why they don't think the Wayfarer parties should get an extension of time. And by the way, that extension of time would apply for all parties, not just Justin and Wayfarer. I'm not going to read it word for word, but I will say some of the more important parts here. Dear Judge, Blake and Ryan respectfully submit this letter in opposition to the Wayfarer parties' motion to extend the April 18th deadline, to move to amend or join additional parties, and for an extension of time to respond to outstanding interrogatories. The motion to amend the court's scheduling order should be denied. The Wayfarer parties entered at the joint request of the parties by extending the time to amend pleadings from April 18th to a date 21 days after the court's last issued ruling on the pending dismissal motions. As the court is aware, the court's model case management plan and scheduling order requires that absent exceptional circumstances, the deadline to seek leave to amend the pleadings be fixed at a date not more than 30 days following the initial pretrial conference, which would have been March 5th in this case. At the time they proposed the April 18th deadline, the parties explained that a departure from that outer limit was warranted to avoid unnecessary additional requests for extension of the schedule. At that same February 3rd conference, counsel for the Wayfarer parties represented that first and foremost, we would like to move the case along as quickly as possible and think that the order that we had agreed to works notwithstanding the amendment of the complaint. And guys, recall that Lively, Reynolds, and Sloan are the ones that are objecting to this. Basically, they did dump like 1,600 discovery requests and over 100 something interrogatories on these guys to answer, which is hilarious because just a fraction of that was something that Leslie Sloan was whining to the judge about. Also, if you want to see the transcript for that February 3rd court conference, it is on my YouTube channel. A scheduling order may be modified only for good cause and with the judge's consent. See Furry Puppet Studio Incorporated versus Fallout Boy. We'll pack it in with a citation like that. I'm sold. The Wayfarer parties do not even mention the good cause standard, much less identify with particularity why it is satisfied here, nor could they. Rather than wait for motions to dismiss to be filed, the Wayfarer parties inexplicably used their sole opportunity to amend as of right on January 31st, knowing full well that further amendment would require leave of court. In other words, the predicament in which the Wayfarer parties now find themselves, wishing that they had drafted their amended complaint differently given arguments raised in the motions to dismiss, is the result of their strategic decision to file an early amendment. The Wayfarer parties have not come close to showing good cause here, where they have known all of the circumstances relevant to the instant request for 2 months, yet did nothing. The Wayfarer parties' assertion that granting this request would not prejudice any party is baseless. To the contrary, the Lively, Reynolds, and Sloan parties would be significantly prejudiced by an unwarranted extension of this litigation, in which the Wayfarer parties have not just propounded voluminous and burdensome discovery requests, which again is hilarious and hypocritical, but continued to advance their retaliatory campaign against Miss Lively and Mr. Reynolds by churning out derogatory content in social and legacy media channels. So these guys still think there's some sort of coordinated smear campaign by the Wayfarer parties, and the truth is, people just don't like you. They're fed up with your bullshit. We've seen it all in black and white in court documents, and you suck. No party should be asked to endure this continuing harm solely because of careless litigation decisions made by the Wayfarer parties. Any reasonably diligent party would have been able to meet the court's unusually generous deadline, and the Wayfarer party's request should accordingly be denied. If this court is inclined to grant any extension of the deadline, the Lively Reynolds party's request that discovery against them for the Wayfarer party's claims be stayed, unless and until they are able to settle upon a version of their complaint that can actually survive a motion to dismiss. And remember that Sloan did try to stay discovery and the judge said no. The Wayfarer party's request for a month-long extension for responses to interrogatories due on April 14th rests on a disingenuous attempt to paint the Lively, Reynolds, and Sloan parties' discovery requests as excessive. Although the Wayfarer parties harp on the aggregate volume of requests for production, such requests are irrelevant to the deadline as to interrogatories. They have averaged more outbound requests per party than they have received, and in any event, the volume of discovery propounded to the 8 Wayfarer parties would predictably be higher than that served on the 4 Lively, Reynolds, and Sloan parties. The Wayfarer parties are dealing with a modest volume of interrogatory requests designed to guide discovery moving forward. Had they not wanted to respond to interrogatories from, say, Mr. Reynolds or Miss Sloane, they could and should have forgone filing utterly frivolous lawsuits against them or agreed to the Sloane party's request to stay discovery. Jesus Christ. The fact that they are willing to make the requested delay mutual does not entitle them to shift the schedule simply because they have decided it is to their benefit to temporarily forego receiving discovery to avoid producing it. What the fuck are you talking about? The court should reject the Wayfarer party's invitation to introduce delay into the schedule at the first opportunity and instead take them at their repeated insistence that they wish to move forward in discovery without delay. Now, if you want to see what Omar the Tilted Lawyer had to say, he and I went over that at the beginning of our stream last night. I will link it in the comments below this video. Let me know what you guys think. Don't forget to hit the like, and I'll be seeing you all again very soon.